Thanking you all for joining us here today. Those in the room get a gold star for navigating downtown traffic just to get here. My name is David Lyons, and I'm a partner and practice group leader at the Business Law Group with Lerners. The purpose of this morning's session is to provide you with updates and insights for those in the business of or with interest in the world of commercial leasing, focusing on various legal topics and related items we've chosen 4 exceptional speakers and experts here today to ensure you get the most out of our morning. Before we get started, I wanted to let everyone know that this program is being recorded and live streamed, and in fact, consistent with the work from home debate, which we're all familiar, about half our audience is actually joining us virtually right now. Oh, that's in full stereo effect here now. The Dolby sign just appeared behind me. So about half our audience is joining us virtually, so we'd like to welcome them as well. It's my pleasure to introduce our first speaker, who happens to be yours truly. And so I will be speaking this morning and just getting us warmed up here. But in terms of my practice, I have a particular landlord side focus, and I'm pleased to act for a number of the region's major landlords in my practice. And so I will be sharing just some of the basics here this morning with us. And so I will introduce our other speakers as we go here, but we're very pleased to have my colleagues Nick Cummings, Lucas Lung, and our friend and partner in business, Rick Spencer from CBRE here. So we will provide further introductions to them as we go on. So without further ado, there we go. 6 tips to better know and collect from your tenant. And I would say that the reason for this talk is essentially based on phone calls that I've been getting recently. We are in a position lately where landlords are in a position where they need to collect, and there are issues that may come up when you go to pull out that old file from the basement. So in my best TV narrator voice, here we go. This presentation is mostly deliberate based on real-life situations, and therefore any similarity is entirely deliberate. The names, of course, have been changed or removed. So we get a call, and the tenant hasn't paid their rent in 3 months. Premises look dark, no kidding, and the phone number is out of service. You dig into your file, find the lease in the name of an entity you've never heard of. There's no personal guarantee or indemnifier. You've got a problem. You do, in fact, have a problem. And so the unfortunate reality is that we are getting some of these calls lately, and it's a difficult time, particularly in certain sectors, such as office. Rick's going to share some comments a little later. I'm looking forward to with a market update and in terms of where we stand. But we are just going to get back to basics a little bit in terms of some tips that I will provide, and perspective on how to ensure that your lease and your investigation of a tenant is as effective as possible to prevent issues down the road. If you're a tenant, I think you'll find many of these tips will provide some perspective and understanding as to what a landlord may be looking for when asking questions and doing their diligence. So the best defense is a good offense, so as I said, we'll be looking at simple tips. And why is this important? Hopefully it saves you headaches down the road. It may also be important to a successor of a property. It definitely is important because the lease documents will be looked at, scoured, in fact, by a lawyer or a broker or both as to the covenants and any issues that they may find if the property is sold. And it may be too late to do it later, and it probably will be. And so it may seem simple, but when the rubber hits the road, time goes by, your future self may thank you later by doing some of these things. Tip 1, starting out nice and slow here, is identifying the tenant. Of course, in Corporate Law 101, we have 3 types of tenants: sole proprietors, partnerships, and corporations. And so the devil is, of course, in the details. And, for instance, there are probably at least 3 different types of partnerships in Ontario law. and there are multiple types of corporations registered in various jurisdictions. And all of those issues will have an impact on protecting your assets and or the ability to enforce against those assets. And therefore, it is important to understand. And to give you an example, on a partnership basis, we had a call of a situation where the lease was dug out, and it turned out there were only two partners, and one of them had passed away some time ago. And so in these situations, it is important to have a better understanding of the partnership agreement, the liabilities, and how or if any efforts have been made to notify of changes in the partnership that you may then need to pull out your lease documents and update them and ensure that you are protected in terms of knowing who the tenant is. Tip 2. This is really my favorite tip of the morning, and I'm hoping I'm sharing something that may be useful to some of you that do this. The Ontario government, a couple years ago, released a system called the Ontario Business Registry, which, while it was problematic when it first came out, has become much better and is a great tool to learn about businesses with a couple of clicks in Ontario. And it uses all of the Ontario business records. So from Google, you can literally Google Ontario Business Registry or search for Ontario Business. Click on that, and you can pull up the screen, pop in a name, even a part name. The keyword searching is very good, and you will find information on any records that may exist with respect to a business operating in Ontario. And so the benefit of the system, it's a comprehensive database of registrations. It does have fairly effective keyword searching. So if, in fact, a tenant has a business name registered in Ontario, you will, with just throwing in the name, so, and I'm going to give you an example in just a moment, but yeah, actually you could show the example, but even if it's, Joe's Coffee Shop, you can throw in Joe's Coffee Shop, and you will, if they have a registration, find whatever registrations are linked there. So in this case, I've thrown in Lerners. And the result is that we show both the active and inactive just being the past registrations, because most of them last for 5 years and then need to be renewed. We see that it's a Ontario Limited Liability Partnership. We see that it's current registration going through 2027, and there is the place of business in London. There is an ability to search and pull the underlying reports so that you can get more information on the organization, whether it's a partnership sole proprietor or similar. I think it's about $30 or so. Or you can call your friendly neighborhood lawyer and they can pull that information for you. But the bottom line is that this information is readily available and it doesn't require a login, and it is very useful to try to track down the tenants or the legal existence of the tenants. There is a similar tool for the feds through Corporations Canada. The keyword searching is not quite as good, so you can't get the operating names as well, but if you do have a federal corporation, you can get the basic information. And in fact, you can get directors and officers information through the federal database, whereas I believe you have to get a profile in Ontario, which is where you pull the additional information. So that's also available to you. The next tip being ask for backup. So get detailed records on have an understanding of who the individuals are who are behind the entity. So a shareholders register in a corporation shows you who actually holds the shares and therefore owns the corporation. Directors and officers registers tell us who the directors and officers are. And a partnership agreement will show the partnership and those individuals who make up the partners. The better option is always to dig a little deeper to ensure you fully understand the legal structure. and require your tenants to advise you and get approval if they intend to make changes. We have a questionnaire form that we can provide, a corporate questionnaire that tries to elicit as much information as possible from an individual if they're applying for a tenancy or any kind of credit situation. But everyone, I would suggest, should use something like this to try to ensure that they get this information. Tip 4, consider the balance sheet. Obviously, I think this in Ontario, again, it's a minor cost. You can identify potential secured creditors, get a better sense of who has claims against the tenant's assets. And particularly if you've got significant build-outs, if you've got complex or expensive fixturing and equipment, this can be very useful information. And often, well, this is one of our first steps when we're in an enforcement situation, is we want to know who we're dealing with and who's going to come calling. But I always suggest that it's also good to know up front who's there, so that you can plan accordingly. The fifth tip, name the tenant correctly. And so, as we know, there are operating names. So Roberts Roofing versus, Roberts Roofing bracket London bracket Inc., which would be the correct legal name. So using the information from the business registry, for example, ensure that the name is correctly stated in your lease and legal documents. This can be useful. Now, if you name a business just by using its operating name, Roberts Roofing, there are likely rules of procedure that you can use to attempt to make a claim against that party, but it is much better and simpler from a corporate perspective to ensure you understand. So if, in fact, Roberts Roofing is Robert Smith, for example, then you would name them, or Roberts Roofing, or you would name them Robert Smith operating as or doing business as Roberts Roofing. And similar example, if it's Jane Smith LLP and it's an Ontario Limited Liability Partnership, you want to be able to state that versus, Jane Smith Law Firm, which may be an operating name as well, but it's something that you should chase down and have an understanding of how it's organized and ensure that the lease reflects that. And the tip number 6, get that guarantee. Consider, obviously, your lease covenant, tenants, indemnifiers, assess risk and the prospect of recovery. In a difficult leasing environment, the more potential pockets you have to collect against, the better. You should consider whether the tenant's risk profile, things like if they're a brand new business, if they have a limited number of assets, high debt levels, indicate that an indemnifier or guarantor is required. And you can also look at that shareholder register or the partnership agreement to consider whom you should be looking to get that indemnity agreement. These are not always easy discussions to have with tenants, but there are ways that you can covenant and investment. Remembering also that in an assignment situation, the liability of an assignor in a lease typically ends at the current term of a lease, and unless the assignment says differently. So if in the context of a guarantee, it may be that you need to also look at your guarantee and whether or not you need an additional guarantor and indemnifier to beef up an assignment in an assignment request. All right, and I hope these tips have been helpful and given you a few things to think about. I'm happy to answer any questions now, and in fact, I forgot at the beginning, but the hot seat mic there is available for you to jump up and ask your question at any time, or it will also have a Q&A time at the end. Right, perfect. So now I'll go back and put my moderator hat on, and introduce you to our next presenter. Our next presenter is Nick Cummings. Nick is a partner in our business law and real estate practice groups. In his practice, he has experience in a number of areas of commercial leasing, including acting for various healthcare practices and practice acquisition deals, which he does regularly. Please help me in welcoming Nick.
Thank you, David, and good morning, everybody. I was just looking over and thinking, geez, we really do need to get on with updating those photos because that one does look a little bit dated. Nonetheless, my presentation is going to carry on with the theme of doing a little bit of diligence up front, a little bit of extra work up front, and hopefully saving some long-term issues down the road. For those of you who are lease fans, you will know short-term pain, long-term gain, right? Offers to lease. These are short-form agreements that are typically entered into before the parties sit down and start negotiating the terms of the full and final formal lease agreement. Letters of intent, offers to lease, agreements to lease, all synonymous, but essentially they set out the material business terms or the basic components that are going to factor into the lengthier lease agreement. Getting these right and getting alignment on the business terms we find often can avoid sort of lease negotiations over the full lease going sideways. Those negotiations are lengthy, they do take time, and therefore they are relatively expensive. And so if that can be headed off at the forefront, it typically saves the parties a significant amount of headache and extensive negotiation. And then save that time down the road. The essential elements of an offer to lease are pretty straightforward. We'll see them behind me here. But once you reach sort of alignment on these material terms, this offer to lease becomes binding in most circumstances. We have to know who are the parties, talk to David Lyons and do your appropriate due diligence ahead of time. What are the premises? Where's the size, location of the premises? What's the term going to look like? What is the rental amount going to be? And other material terms that we're going to talk about in the presentation here. Along with this, we want to make sure that we accurately describe sort of the building in which the premises are located, make sure that we've got alignment in terms of who the landlord is under the lease as well as the owner of the building. If there is a misalignment there, we need to understand what that relationship looks like legally, and then also determine the legal description of the premises. Beyond these essential terms, however, what I want to talk about are some of the other material terms that you might wish to include in these agreements to lease before you get to the full and final lease agreement. These are very case specific, very fact specific. They will change from tenant. The lease agreement off the ground, get the tenant into the space. The question becomes who is paying for what? Is there going to be rent paid while the tenant is doing its fixturing, building out its leasehold improvements? Are there going to be improvement allowances that are granted by the landlord back to the tenant? So these would be contributions towards the build-out costs. Some of these can be quite expensive. We're seeing a number of these sort of big box, more shopping malls that are coming out here with standalone pads. Who's going to be building out the interior of these standalone stores? That could be a significant investment. If the landlord is going to be contributing towards some of that in the way of an allowance, when does that allowance get paid? We have to think about things like construction liens coming up and ensuring that the landlord is not paying and then also trying to recover because it's got lien holders advancing claims against its property there. During the fixturing period, is the tenant going to be paying rent? Are they going to negotiate simply paying additional rent or TMI and utilities during this period there? So these are all options that you might want to consider when it comes to discussing how the actual space is going to be built out for the tenant. From the tenant's perspective, getting these right gives you a little bit of clarity. It helps you also cash flow the very expensive upfront costs of getting the business off the ground and up and running. When the tenant is using the premises and the offer to lease, you want to, of course, from the tenant perspective, make that use broad, whatever your primary business is, plus whatever ancillary business streams that you have, future flexibility if you do decide to pivot. And then, of course, from a landlord's perspective, when it comes to the use of the premises, you want to keep that more narrow, right? If you're going to grant exclusivity covenants to other tenants within the property there. You want to make sure that those are all aligned across your lease agreements. You want to have control over what your tenants are capable of doing in there, so you don't get a tenant pivoting to a different type of business that might not align with the general theme and brand of the overall property there. One of the interesting ones that has come up in the last few years is many of the lease agreements contain obligations on a tenant to continuously operate their business, right? Which during COVID times with lockdowns presents a bit of a challenge. Without an appropriate sort of force majeure clause in there, it does become a bit of an interesting debate, particularly when the lockdowns were lifted and the tenants could go back in. But as we've seen, work from home has become much more prevalent these days, and so you have all of these vacant premises that are out there, which could constitute a technical breach under the lease. Within the agreement to lease as well, you want to make sure you've set out your term and your renewal options, right? A lot of the times we will see an initial 5-year term with a renewals correct. We've got an interesting case right now where, you know, it was a 5-year term plus 2 5-year renewals on it, but the parties hadn't turned their minds to what that renewal rent would be on the exercise of the extension option. Interestingly, diving into the case law, it appears that the extension option, in fact, is void for uncertainty because the parties did not adequately address what the rental calculation would be or how they would align on the rent. Therefore, thinking that as tenant, you've got, you know, 15 years between a 5-year renewal plus 5-year extensions, 2 5-year extensions. In fact, you've only got 5 years, and with market rents going up significantly, that creates quite a problem for the parties and quite an interesting dispute. Other material terms that are set out in here, if, as we see in most cases, you are dealing with a net lease, what is going to be the operating cost? What is going to constitute the additional rent that the tenant is responsible for? Net leases typically set out that the tenant pays a basic rent amount plus an additional amount that goes towards covering sort of the maintenance, repair, replacement obligations for the property. So all of these distinctions can have an impact on what that overall amount ends up being for the tenant. From a drafting perspective, if you set this out and get alignment in your agreement to lease, you will have less of a negotiation in the final lease agreement, and you can point to that offer saying, no, this was already agreed upon. But a couple of the sort of pitfall areas that we typically see in here, one comes when you're dealing with things like capital repairs or replacements, so items such as a roof or a parking lot or an HVAC system, which can be quite expensive. Is that something that you are capable of passing down in any single year to the tenant, or is that something that is going to get sort of amortized and spread out over the useful life of what that capital repair or replacement will actually give you? In addition, landlords, you'll want to turn your minds to whether or not you are charging sort of an administration fee or a management fee on the operating costs. It does take, of course, time and effort on the landlord's part to coordinate this work, get the work done properly, ensure that you've got effective warranties in place for the work, right? You want to be compensated for the time that you put into sort of maintaining a first-class property there. But from the tenant's perspective, 15% sort of carte blanche across all of these operating costs can in fact be quite a big number. And, one of the things we would point out is whether or not there is duplication within that management fee and the operating costs themselves. So, for instance, if the landlord is paying itself a salary or paying somebody a salary to do sort of management and repair work at the property there, should that 15% also be charged on top of the salary that is getting paid out for that type of work? In addition, things like simply paying utility bills or property tax bills there, which don't involve a lot of effort, is that something that you want to negotiate perhaps as an exclusion for that administration or that management fee there? Ultimately, one of the things that we would also recommend too is putting an obligation on the parties to, well, in particular the landlord, to produce an annual statement of what these actual operating costs are going to be. Most scenarios we find that the landlord is estimating these costs at the beginning of a lease year, right, and then reconciling them at the end of the lease year once the actual expenses have all been accounted for. From a tenant's perspective, without the right to sort of have supporting documentation or an ability to kind of audit and inspect the records to reconcile what these costs actually were, you're essentially kind of relying on the landlord and its calculations without that support and backup. So again, getting those types of terms right can be very helpful up front. In addition to this, one of the things that we find people don't to go through and improve the premises or restore them back to sort of a base building condition, a vanilla shell, as we'll call it. Is there an obligation on the tenant to remove its leasehold improvements, its installations that they've made there? You know, from a tenant's perspective, typically you want the ability to remove your own trade fixtures and your equipment, anything that you can essentially pick up and walk out the front door. But things which, you know, might have been a bigger investment, restaurant businesses are a great example. Are you taking that equipment out? And then from a landlord's perspective, is your tenant obligated to go back in and repair any damage that is caused from the removal, right? Obviously, you don't want to walk back into a building, you got a bunch of holes in the wall, and that is your obligation to fix. Interesting situation we had with a dentist. I mean, dentists, we all know they have those chairs that are bolted to the floor. They've got their suction equipment, all these other installations that are quite extensive, right, and do cause a lot of damage upon installation, right? On removal, you know, if there's a debate as to whether the rent, because that is what the overholding provision happens to say in the lease. So very interesting situations. Again, spelling that out up front, everybody understands what their respective obligations are, can avoid a lot of headache down the line there. Beyond the extension of the lease, some other provisions that I wanted to talk about here before we wrap up. Assignment, subletting, and the often forgotten change of control provision is an important one to get from both sides. From a landlord perspective, of course, you want to understand who is in your property, who is operating out of that space, and you want to have a degree of control over that so that the person can't simply swap out for or we disagree. Some specific tenants like professionals, dentists, optometrists, veterinarians, for example, you know, beyond sort of an assignment of the lease might enter into regularly a subletting situation or have other associates that are practicing alongside them. So in these sorts of circumstances, it's important for the tenant not to have to go to the landlord each time you bring in a new associate to your practice to help you operate. But from the landlord's perspective, again, you might want to at least have knowledge of who's going to be operating out of there, particularly if your sort of principal of the tenant, if the primary person that you were originally dealing with is not going to be present continuously at the premises there. Subletting is also an interesting one these days. Again, that's something that typically, if you're going to be carving up areas of the premises, subdividing them, making installations, might be. And then change of control, this is one that I did want to mention. You know, these cover the situations where a tenant, when it sells its business, rather than selling the assets and having an entirely new company move in, simply enters into a share sale transaction where all that really changes is the underlying owner, not the actual sort of name of the tenant itself and the business itself. Changes of control do require a little bit of inquiry and due diligence on behalf of the landlord side. So, you know, we would always recommend having a provision in the lease that says the tenant has to notify you before they go through a change of control transaction, so before they enter into and complete the sale of the shares. But ultimately, from a landlord perspective, you know, if it's business as usual and you haven't really noticed a change in the underlying business of the tenant, you might not know that there has been a change of control to which the tenant either simply forgot or chose not to notify you about. So when you're negotiating these types of provisions, we do recommend that you have sort of an audit right of the tenant's books and records and ability to go and inspect things like the shareholders registry to see if there has been an effective change in the voting control of the tenant and the principles that are involved. But of course, from the tenant perspective, you still want to have flexibility that this does not apply to things like tax reorganizations and other sort of assignments. For their businesses, relocation and demolition and redevelopment provisions within a lease. So these obviously give landlords plenty of flexibility within their building, particularly multi-tenanted buildings, to be able to move tenants around, to be able to sort of reallocate space and rentable areas within the building. But from a tenant's perspective, relocation is highly disruptive to your business, often involves downtime. You're having to print new marketing materials if you've got a change in sort of the municipal suite or unit number that you're associated with. If it's a relocation from, say, street facing to interior, you have less visibility, less traffic. That can also have material implications for the business. So you want to set out what are the rights and obligations with respect to things like relocation, demolition, even more so. Are you going to have to buy out the lease? Can the tenant expect any sort of compensation for a demolition situation? What are the notice requirements? So if you do want to do something that is material like this, do you have an obligation to give the tenant, say, 6 months, 12 months notice, 30 days? What's appropriate in the situation there? And these are all terms that, again, hashing them out front rather than simply handing over a standard form of lease that nobody agrees on can save you time down the road. Finally, one of the things often forgotten that is relatively straightforward that we would remind everybody is what the insurance requirements are. We highly encourage everybody to obtain certificates of insurance, which are often spelled out within the lease, but not often produced as leasing arrangements begin. So having those obligations clearly set out, having those certificates produced, and ensuring that the right parties are named within the certificates can also save everybody some time and headache down the road and ensure that risk is being treated appropriately there. So these are just a few provisions that we wanted to set out and remind you about today. I will open it up if there are any questions here. Happy to address those.
Only use the speaker or the microphone, Nick, because the pajama crowd at home may need to hear the question.
Very good.
So, question on lease renewals.
Yeah.
I find this is one of the things often overlooked by tenants in particular, especially a tenant who maybe is a single user. If you've got multiple locations, you've probably got a system in place that catches these and sends the notices. But I hear from tenants often, I just got notice from my landlord, my rent's triple. And so what's your renewal provision said? Well, I was to renew last November. Did you? No, I did not. So if that happens, I'll sort of give them the benefit of the doubt and say, look, sign a renewal, acknowledge we missed it, but now we have a renewal and we're going to play fair. But without it, it's totally a one-sided game, right?
Yeah, and so as lawyers, we're trained to say that there is no clear-cut answer. So I'm going to go with the traditional, it depends. You're absolutely correct. I mean, renewal provisions in a lease, if I think to what a typical one would often say, tenant has to give written notice in accordance with the terms of the lease within a prescribed time period before, call it the then current term expires, right? So written notice given not less than 6 months before the expiration of the term, right? And you're correct, most tenants aren't tracking that. Most tenants aren't thinking, okay, I've got to send a letter to that specific address by registered mail or personally deliver it to the landlord, right? And that can void a renewal option in its entirety. There is quite extensive case law out there that say, for instance, if there's emails back and forth between the landlord and the tenant sort of negotiating the renewal up until sort of that 6-month hard stop point in time occurs, right, that can be binding, and that a landlord cannot then argue sort of a procedural argument that the renewal option is void simply because it wasn't delivered exactly in accordance with the provisions of the lease. But in your example that you gave where, everybody simply kind of forgot about it, we are 12 months ahead of the expiration of the previous term. To me, in most cases, that is probably now an overholding situation, and the tenant really does lose any and all contractual rights that they would have had with respect to the renewal option that was never validly triggered. There's always, the Supreme Court has enforced this and does enforce this quite regularly, and my litigation colleague Lucas can explain this much better than myself, but there is an implied contractual duty to sort of act reasonably and in good faith. So a landlord, has to make sure in situations like that, call it everything is above board, right? And you aren't doing anything sort of nefarious or that would prejudice your position should a tenant challenge this. From a tenant's perspective, your recourse would be relief from forfeiture, which I think is going to be covered a little bit later on, but it's essentially an application to the court saying, notwithstanding the strict provisions of the lease, it was my reasonable expectation that the renewal sort of was exercised. I was paying rent in accordance with the invoices that the landlord kept giving me. Give me another kick at the can, basically, to solidify that 5-year extension. And in that case, the courts aren't typically, and this is in my example I gave earlier with the tenant that, didn't have here's how we calculate the rent for the renewal term clause in that lease. The issue is that the courts won't guess at what the applicable rental rate should be. That seems to be where the case law really focuses, is it's not the job of the courts to determine, what the rent is, whether it's fair market rent or otherwise. And I think that's why they've tended to say that, the terms just weren't certain and therefore the renewal option doesn't exist. So, I think in that kind of circumstance, there might be an obligation on the landlord and the tenant, particularly if there is sort of written or doesn't necessarily have to be written, but if there are exchanges leading up to that 6-month point about the renewal, right, there might be an obligation that it's a fair market renewal rent that should apply, and the parties have to act reasonably in determining that.
Thank you. Sort of follow up on that is that often if a landlord is approached by a tenant and they want to have the conversation about a renewal, I've always recommend to the landlords that if they want to, they got 3 months in advance, say, get them to renew early.
Mm-hmm.
That way, I think you're obligating both parties to be fair. If you don't have that, I think all the cards are in the tenant side because they don't like the answer they hear, they don't do a renewal.
Yeah, I think that's a fair. I think that's a fair statement. I mean, I think what's important as well is what does the lease say about how that renewal rent is calculated, right? I mean, a lot of the ones that we come across, it is sort of the fair market rent for similar premises within a similar area, right? And then if the parties cannot agree, as you say, then there's usually an arbitration mechanism that can be triggered and the parties will arbitrate over it. And the arbitrator's decision will kind of become the renewal rent going forward as firm and binding. But I would be inclined to agree with that statement. I mean, arbitration is not cheap. Everybody, landlord and tenant, they're going to have to get their own experts involved to determine or make that calculation as to what the sort of fair market rental rates would be. Rick, we've done that in the past as well. And, there's a lot of uncertainty out there, right? Because, what is a similar premises? Is the similar premises one that is sort of retrofitted the same way as the tenant, right? Is it, if it's a restaurant, are we comparing restaurant to restaurant? Are we comparing, other ones that are closer in that area that might not be a restaurant to a restaurant? I mean, there's so many different ways that you can kind of attack what a fair market rent may or may not be. And that creates a lengthier arbitration, which costs everybody money. So I do think, addressing this early gives the parties more time to engage the appropriate experts to get the background information, get the comparables from, qualified individuals, and then have a debate about it without having to resort to the arbitration. But it is something that can be, quite difficult. And I think a lot of parties might just say, okay, fine, there is no meeting of the minds, we're too far apart, and therefore we are just going to end the leasing arrangement in that circumstance. Very good. All right. Well, I'm going to hand it back to our moderator here, Mr. Lyons. Thanks, everybody, and it's good to see everybody out in person again here.
Thanks, Nick. A couple of points to follow up. First of all, just for your tenant clients, the landlord statements are always right, and there is no need to, there's no duplication. So we just get that cleared up right now. On Peter's follow-up question, I think it's interesting because usually it's never simple. It's never just, I totally forgot and missed it. It's always shades of gray, and so it's, we talked about the renewal, or we maybe sent an email and I mentioned I might want to renew, and then it becomes a much more complicated legal question, because I think there is, that's the first thing. If someone's trying to challenge a missed renewal period, they'll look at is what the history is between the parties, and something that we see. But it's certainly good questions. Thank you, Peter, for those. And our next speaker is from our commercial litigation group and a partner in our Toronto office, Lucas Lung. Lucas is one of our go-to guys for lease enforcement matters and related issues when things go sideways in a lease matter, which sometimes happens. As part of his practice, Lucas regularly advises both landlords and tenants on leasing issues. Please help me welcome Lucas.
Good morning. So my presentation is very landlord-sided, and I just want to make clear that we also advise tenants, and I can give a different presentation next week. But this is more focused on enforcement issues, and in particular, what to do when your tenant defaults on specific provisions in the lease. And it's not intended to be comprehensive. I don't suspect that most landlords are going to run out and do most of these things by themselves. Our expectation is that landlords and tenants, for that matter, when they run into these types of troubles, will engage counsel and get the proper advice that they need that is particular to the circumstances. So what happens if you have a commercial lease and there is a default under the lease? Well, the first thing you'll want to do is identify the specific provision that is being breached in the lease. And that's important not only for the purposes of giving notice, but also determining what specific notice requirements are necessary. So you'll want to go through the lease and identify the specific terms that have been breached. And then a landlord will want to identify what the specific notice provision is, and each lease will be different. It's common for leases to have different terms of notice for different types of breaches. Many leases will have shorter notice periods for non-payment of rent, and then the landlord can re-enter the premises. But for a non-monetary default, the cure period may be 14 days or it may be 30 days. Now, the landlord has to consider what its objectives are. And, does the landlord simply want compliance with the lease and a cure of the particular default, or does the landlord want to terminate the lease? And that will largely inform what remedies the landlord will pursue. So, for example, if a tenant is not paying rent and the landlord wants to terminate the lease, then it can give proper notice and proceed with re-entry. But if there are circumstances where the landlord doesn't want to terminate the lease, and the landlord simply wants the lease to continue, but have the For example, if it's a monetary default, then collection of arrears, then there are other steps that can be taken, and we can talk about distraint a little bit later on. There may be non-monetary defaults that the landlord simply wants remedied, and they may relate to issues like improper use of common areas. They may relate to parking or signage or other issues of that sort. And it's a notice of default is often useful to secure compliance when you have a tenant that either disputes whether there is a default or not, or has some argument about the specific terms of the lease. It's also important to look at the current term of the lease. And this is an issue that Nick and I ran into in a case last year. If the term has expired and then the tenant is overholding, and the landlord wants to terminate for non-payment of rent, it may actually be preferable to terminate the lease under the overholding provision rather than to give notice of a default. And so in those circumstances, there's almost no defense to the termination. There's no way that the tenant can actually avoid the termination. So that's a situation that Nick and I had recently, where there was an industrial property of about 105,000 square feet, and the tenant had not paid rent for some time, and the arrears were substantial. But rather, the landlord wanted to terminate the lease, but rather than move on the default, we saw that it was an overholding situation. In those circumstances, simply gave 30 days notice and terminated the lease on that basis. And one of the benefits of that is that there is no relief from forfeiture, because there is no forfeiture. There is no default under the lease at all. It's simply a termination of the lease in accordance with its terms. So let's move on to termination and reentry. So assuming the landlord has identified the specific notice requirements in the lease, then the landlord will give notice. And if the lease is, well, first of all, if the lease is silent about giving notice of default for non-payment of rent, then under the Commercial Tenancies Act, if the rent remains unpaid for 15 days, the landlord can simply proceed with reentry. But let's assume that the lease has a notice requirement, and in those circumstances, unless there's something specific in the lease, there's no real prescribed form for the notice. But at a minimum, for the failure to pay rent, the notice of default should include the specific amount that is owed as of the date of the notice, reference to the specific section of the lease that deals with that particular type of default, and also make clear that the landlord will re-enter the premises if the default is not cured within whatever number of days is specified in the lease. Now, for defaults that don't involve the failure to pay rent, you'll have to have regard to the requirements in Section 19 of the Commercial Tenancies Act and Section 19 sub 2 of the Commercial Tenancies Act. And that provision includes specific notice requirements for any breach that does not involve the failure to pay rent. In particular, the notice has to specify the particular breach that's complained of, and if the breach is capable of some kind of remedy, then the notice must set out what steps the tenant must take in order to cure the breach. If the landlord is requiring compensation for the breach, then the notice must set out the amount of the compensation that is required, and it must give the tenant a reasonable period of time to remedy the breach, and that reasonable period of time will often be set out in the lease. So, for example, the lease may say that the breach has to be cured within 14 or 30 days or whatever, and that is the period of time that needs to be included in the notice. Now, the courts have held that those requirements for notice for non-monetary breaches are strict. They have to be adhered to. So there has to be a proper notice given under this provision. So once a notice of default is prepared, it has to be delivered to the tenant. And now is not the time to screw it up. you need to go back to the lease and see how the notice has to be delivered. And, I've had landlords who have simply said, well, it's good enough to just send an email off to whoever I normally deal with at the tenant. And unfortunately, you have leases that may not allow for that. So it's important to go back to the lease to determine exactly how a notice is to be sent and to whom and in what manner. And in particular as well, the provisions of the lease may provide that if you deliver a notice in a particular day, a particular way, that it will not be effective for a certain number of days after delivery. So these are things that you'll want to check and you'll want to ensure that you adhere to strictly. So notice is given and it's done properly. You followed the provisions under the lease, and premises. And at that point, there are a number of considerations, and one of them is obviously the landlord could simply just go and re-enter if it wants, and it can do it with its own staff or use seek assistance from third-party vendors. But in some cases, a landlord may decide that it's prudent to go get a court order before reentry. And if you have circumstances where you have a tenant, a longtime tenant, that has been in possession, in particular if you're dealing with a non-monetary default and there's a dispute about whether there actually is a default or not, re-entry and simply locking, changing the locks may cause enormous disruption to the tenant and consequently potential enormous liability for the landlord. So in certain circumstances, although it's a costly and time-consuming process, it may make sense for a landlord to bring an application in court for an order that the lease is terminated. That won't be the case that won't be always the case, but in certain circumstances that may be the prudent way to proceed. So I was going to talk about relief from forfeiture. So under Section 20 of the Commercial Tenancies Act, a defaulting tenant can apply for relief from forfeiture, and the application is made to the Superior Court. And in determining whether to grant relief from forfeiture, the court will look at all of the circumstances of the relationship, including the conduct of the party seeking the relief from forfeiture and the gravity of the breaches involved. The court will also look at the impact of a refusal to grant relief on the parties, not just the tenant, but also the landlord. But usually, a tenant will get relief from forfeiture. If we're talking about an issue relating to the non-payment of rent, usually a tenant will get relief from forfeiture at least once. But the tenant will usually have to either pay all of the arrears by the time of the hearing, at least that's a smart thing to do, or have a coherent plan as to how it will be paid in short order in order to get relief. The court will not grant relief unless it is satisfied that the tenant is either on its way to curing the breaches or has cured the breaches by the time of the hearing. So from the landlord standpoint, in the face of an application for relief from forfeiture, it's not a foregone conclusion that a tenant will always get relief. I mean, certainly there are circumstances where a tenant will not get relief, and including circumstances where a tenant is constantly late paying rent, or where the arrears are really substantial and there's no real way of digging out of the hole. But from the landlord standpoint, if relief is going to be ordered, then what will matter will be the terms of the order granting relief, and the landlord will want to ensure that there is a coherent plan going forward, that there are specific terms relating to payment, and also that there are terms relating to the payment of any additional fees and costs as well for the application. So separate and apart from all that, a landlord can bring an action against the tenant for the payment of rent. And that action is simply just an action for breach of the lease, for arrears, as well as for future rent under the lease. And in almost all situations, and I'm sure everybody in this room knows this, there is a duty to mitigate. So the landlord will have to go out there and attempt to re-let the premises. The landlord cannot simply sit back and say, well, I've got a 20-year term or 15-year term and sue for the balance of the rental payments for that term. I just have a couple of brief comments about bankruptcy situations. If there is a bankruptcy proposal made by the tenant, then that will stay the right of reentry. The bankruptcy or proposal trustee will have 90 days to elect to disclaim the lease, or can assign the lease to another tenant. But in the circumstances of assignment, all of the arrears will have to be paid. If the trustee disclaims, then in those circumstances, the landlord will be able to claim up to 3 months of arrears and 3 months of future rent, and that sits as a preferred claim within the bankruptcy. So somewhere above unsecured creditors and below secured creditors and other preferred claims. So just a couple of quick comments about distraint. And distraint's kind of a weird thing. I don't know anybody who's ever been involved in a situation of distraint, because it's essentially a situation where a landlord says, I don't want to terminate the lease, but I'm going to come in and seize all of your property and sell it, but we're going to have a good relationship anyways going forward. So usually it doesn't happen. I've been involved in situations where there have been notices that have gone out, but ultimately matters have been resolved. But there are a number of different requirements, and the sort of preconditions to exercising distraint is that there, first of all, is a continuing landlord and tenant relationship. You can't seize property for the purposes of distraint while also terminating the lease. I think that's called theft. The tenant remains in possession of the premises, and that there are rental arrears that are due and payable. Now, there are a number of items that are exempt from distraint, and there are special rules relating to subtenant goods. Fixtures can't be seized. I think wild animals and things like that can't be taken. Property that's owned by third parties, money, you can't distrain on money except in certain circumstances. I think if it's in a bag or if it's in a container of some sort. So there are a number of items that are exempt from distraint. There are notice requirements under the Commercial Tenancies Act, and so under Section 53, you have to give notice of seizure, and so the notice has to be left in a conspicuous place, and it has to say that, if you don't cure your default, then we're going to start selling the goods that we have seized. You have to provide a notice of storage, and you have to, within a week, tell the tenant where the goods are being stored. And there's also, at some point, you have to provide a notice of costs, which set out the costs of the distress. And just in terms of practical considerations, like I said, exercising a right of distraint is pretty rare, because you're going to have an ongoing relationship with the tenant, and so circumstances are going to be very, very infrequent where it's going to make sense to go in there and take goods while you still want the the tendency to continue. Although, some of those circumstances may be that you view the continuing lease as being valuable. And what you don't want to do is necessarily terminate, but you want to compel the tenant to continue to occupy the premises. So if there are any questions, I'm happy to take any. I do have one comment about the renewal discussion that one of the questions about renewal for Nick. And I think Nick had said that the one thing that you could look to is if you don't properly, if the tenant doesn't properly exercise a right to renew, is relief from forfeiture. I'm not sure that would be something that could be addressed with relief from forfeiture, because it wouldn't be a default. It would simply be, I guess, from the landlord's perspective, a decision not to elect to exercise a right under the lease. So I'm not sure that would necessarily be a default that could be cured with a relief from forfeiture. And then just in terms of absolutely, landlords have an obligation to, and actually both sides have an obligation to perform the covenants under a lease in good faith. What that means under the law, I mean, there is a general duty of good faith performance, but it is a duty of good faith performance. What that duty doesn't do is it doesn't change the terms of the lease. So if there is a discretion to be exercised, and that is supposed to be exercised, no earlier than whatever X date, and at least up to whatever Y date, and it's simply not exercised. If there's a clause in there that says, or at any other time at the discretion of the landlord, then that's a different issue. And in those circumstances, the landlord does need to exercise that particular discretion in good faith. But if there isn't that type of language in the lease, then I'm not sure that the duty of good faith would compel a landlord to accept notice that simply wasn't given within the period of time that was specified in the lease. So just a couple of comments on some of those other issues. Sorry, go ahead.
No, go ahead. Just a quick question, and I apologize because I've never had. Say it's a franchisee and the franchisor is the indemnifier, and he wants to notice to the franchisee. Is there any best practices in notifying an indemnifier or a guarantor? Yeah,
so sorry, I should have mentioned that. I think there absolutely is. And one thing that you should do when you're looking at the lease, and you're looking at the guarantee as a schedule or whatever, like don't miss that, because there may be notice requirements for indemnifiers or guarantors, and notice should be given at the same time. So.
Quick question. I don't know who's best to answer this, but with respect to quiet enjoyment in a lease document, what are the rules when it comes to, if there are any, the landlord relationship with the tenant? Can a landlord go in to my premises at any time without notice and do an inspection, or does the landlord need to give notice? And what if the lease is silent on that matter?
Well, I mean, I'd be happy to let Nick answer this, but my understanding is that if there is no provision in the lease that allows for that type of entry by the landlord, then the landlord simply doesn't have a right. So we had a problem with, Nick and I had a case. One of the rental units in order to do some work and to do environmentals, and we can't get in. Because there's no provision in the lease that allows for that type of entry. And it's been a real problem. So that's been ongoing for a couple of years. And at this point, It's not clear that there's any way that we can get in at all. We might just have to let it run out.
So if the lease is silent, that's the issue you've got there. And if the lease isn't silent, but says there must be no 24 hours notice or 48 or whatever it might be.
Nick, do you have a specific response? I would say that it depends on what the lease says. And if the lease provides for that type of notice, then that's what governs.
Yeah, I would agree. I mean, I think landlord in that circumstance, one of them is the landlord must provide reasonable. What is reasonable notice in circumstance, right? And I think from the landlord's perspective, you want to err on the side of caution because you don't want the tenant to then have, the landlord has breached the tenant's right of quiet enjoyment. I think unless it's an emergent situation, like you're concerned about, pipes breaking and flooding or these sorts of things, right? Unless it's emergent, 24 hours is probably the shortest time period that would constitute reasonable, right? Another factor might be, reasonable notices, hey, we need to get in there. X. Please let us know if you want to have a record of the tenant, present when the landlord is going in. If you take like a doctor's office as an example, right, you've got very sensitive patient information in there and very significant confidentiality obligations, right? You don't necessarily want the landlord going in at 9 o'clock at night with the contractors to do whatever the landlord needs to do, and then all of a sudden now you've got a confidentiality privacy issue on your hands. Also, I agree with Lucas, defer to what the lease expressly states, and then if it's not clear, if it's something that's more kind of ambiguous or broad, like reasonable notice, then, err on the side of caution, give plenty of time, ask for whether or not the tenant wants to have a representative present when you go in to do the work, and, just turn your mind to who is the tenant, what's in there, and what steps do I need to take as landlord to make sure that, there's nothing liability-wise that can come back on me after the fact that the tenant does get frustrated.
So the landlord can come in after hours and just on their own, no notice, just walk in, unlock the door, and check the premises, check for whatever they're looking for, and then advise the tenant that they've done something correct.
I would say chances are not, because
Unless the lease says you can.
Unless the lease says you can, but there is a reasonable. You are, not invited to the premises.
I mean, I think the important thing is that it's always better to have a healthy relationship between the landlord and the tenant. And if you have a cooperative relationship and there's transparency, there usually is not going to be an issue, as most of the people here will know. Sorry, go ahead.
So tenants in monetary default, give a notice. Business is ongoing. No one's communicating back to the landlord, the people that need to communicate.
Well, I mean, it depends on.
I this about 10 years ago. It really just got disappeared.
Yeah.
The business is still there, and the employees are still
Yeah, I mean, the notice period, the amount of notice will be determined by the lease. So if you have a lease that says that, and you're talking about a monetary default, not paying rent. So if it says that the landlord can re-enter upon giving. I mean, I think that's the whole point. So, yeah. Oh, sorry.
Sorry, this may have another question.
Sure.
Reconciliation. If tenant is past termination, so they've terminated, they've left the premise, and they still have a balance of reconciliation, but that is not going to reconcile for potentially 6, 8, 9 months.
Yeah.
Is there any recourse to an indemnifier or guarantor if the tenant, or the past tenant, refuses to pay that reconciliation for the final year?
Well, I don't see why there wouldn't be. I mean, if you have a guarantor under the lease, then the guarantor would be guaranteeing any amounts that are owed. But it relates to the term of the lease.
Okay.
Yeah. So unless you've got some other answer.
Yeah, I think property. So that would be one thing to consider. Second thing would be whether or not there's any lease that, certain provisions survive the termination or natural expiration of the lease. But I would agree with Lucas. To me, that is a debt of the tenant, arrears of the tenant that originated during the term, and therefore you would have your whatever the applicable limitation period is beyond the end of the term to go back and cover it.
Mm-hmm.
Thank you, Lucas. Always some food for thought. I would say in the case of distraint that my experience is it's not usually that you want the stuff, it's you want to get rid of the stuff, and that's usually more of a problem sometimes. But anyways, onward and upward here. Our closer for today is our Rick Spencer, a vice president and broker with CBRE's London office. He's our special guest panelist. He began his career in 2012. Prior to that, he had extensive business background running a steel contracting company for over 25 years, making him a valuable source of information for business owners and investors. He's one of our go-to folks when clients need advice from an experienced broker, and we're very pleased that he's agreed to join us to share some perspective on the local market and insights. Please join me in welcoming Rick.
Thanks, David. Looking for my box to stand on, but I don't see it here. First of all, I want to say thanks to Dylan for operating the slides. Dylan asked me if I had any cues that I would use to, push for a slide change, and I said this, and apparently that didn't really go over too well, so we're going to go. That works out just fine. So I am talking about investment, going to hit very high level on the investment side of things. Hybrid working, getting people. Yeah, so Dylan, we can go right ahead there. There we go. So this is sort of a sidebar, but it certainly has this particular example. I'm talking about office leasing. So let's talk about what the tenant wants. What the landlord wants truly hasn't changed much. It's the same stuff. They want long-term leases. They want strong financial covenant, and they don't want to pay anything for a build-out. That's in their perfect world what the landlord wants. What the tenant wants has changed dramatically. What the tenant now wants, short-term, very flexible leases. They'd love to have termination clause. We see those popping up more than ever. So the tenant wants great flexibility. They don't want to do that 10-year term anymore. 7 even, and even on new build-outs, we're seeing 5-year terms, which is really in the past very unnormal. Very unnormal? Very not a normal thing to have. So yeah, we are seeing that big change. In fact, we have a national tenant in one of the downtown buildings, and they started their renewal with a 1-year renewal term. And it's because the tenants just don't know where all this is going. I'll talk about that more with the hybrid working, but it's very, very tricky. So we're certainly seeing the tenant wanting way more flexibility. That is not the slide I wanted, but can we go back if you can, the hybrid one. Well, it's not there. Okay. Yeah, right. George, come on up. Yeah, exactly. So it's okay. We'll wing it anyhow. Basically, the hybrid working model, one of the big things, getting people back to work and so on, trying to get people back. One of the biggest things, and at CBRE, we all know we do a boatload of research. We have a really strong research engine. And the workplace strategists have found that these large firms, they got to be together. Like the top executives got to be together on why. Like, why do we want people back to work? Why is it important? The message needs to be very, very clear. And they're finding even at the executive level, that message can't be, they can't come to terms amongst themselves on why. It's especially difficult when businesses are doing well. So if they're succeeding, they're doing well, market share is good, sales are strong, and then you're trying to turn to your people and say, hey, come on, we want you to come back. The why can be difficult to figure out. So actually it's interesting because I spoke to a CEO of one of the biggest employers here in town earlier this week, and he was telling me some interesting facts that they asked their people to come back 3 days a week. 25 to 30% came back Tuesday, Wednesday, Thursday. Less than that on Monday, and much less than that on Friday. So you could imagine you're trying to get your folks back, and you ask them all to come back 3 days a week. 25% come back. Like it's a big issue, and it's tough for them to get. Like I said, you know, what those landlords need to start to do, or sorry, what these owners need to start to be doing is really getting to the heart of the employees and saying, listen, we want you to come back for collaboration. We need you here. You're important to the organization. We need your mentorship. Like, this is the kind of things that we're going to start to see. And as he was saying, one of the big items is culture. Like, where does the culture go in these big companies? And it's been centuries sometimes that these companies have been around, certainly decades. And they've combed this culture, and not only for themselves internally, but externally as well. And who knows where that goes. It's as he said, he doesn't really worry about that too much today, but we talk 5 or 10, 20 years out, 70% of your people are working from home. How's that look? So there's a great deal of controversy around getting people back and what it's going to do and how it's going to affect people. So as far as investment go, now I can actually use the slides. As far as investment goes, certainly nationally from a cap rate perspective, if I'm sure all of you know basically what a cap rate is. It's basically the return on investment that the investor has when he's investing in a product and an asset. Office, needless to say, by the way, all classes are up cap rates. Simply interest rates drive financing, which drives a cap rate. So if I was at 2% financing and I want a 2% return, then sure, 4 or 5% cap rate makes some sense. But if I'm at 5.5, then my 7.5 or 8% return ends up kicking in. So there's a huge discrepancy right now, and so the see it, but it's going to take a bit of time, and certainly in certain different asset classes. So I do have this slide, and then we have the other side, but we'll stick with this one for just a minute. So there's that part of it. What's important to note, these asset classes really make a big difference. I mean, office, obviously, the risk is high, right? Your vacancy's up. Your terms, everything good, bad, and different is kind of going the wrong way. Whereas when we get down to industrial and multifamily, I mean, these are strong asset classes. Our vacancy rate, like, let's use an example. Office downtown London right now, the vacancy rate, 26%, right? It's ugly. And then we go to industrial, and we're talking less than 1%. Just over 0.5%, I believe, is around where that market is. So if I'm going to use this example, but if I'm an investor and I'm looking at, and I'm a seller as well, whatever. So I'll put my investor cap on. So I'm an investor and I'm looking at an asset, an industrial asset. And I look at the lease, the 10-year lease, it's got 3 years left. So it's 7 years, 7 years old, it's got 3 years left. The tenant is paying $4.50 square foot, which is, not out of the norm for 7 years ago. So now I'm looking at this, and okay, 7 years in, I know the market rate is $8. So there's huge upside on that particular asset class and this particular example. So as an investor, I may pay a really skinny cap rate. I may go break even because I know 3 years out, things are going to change for me. So there's big discrepancies in cap rates based on situations and also based on the asset class. And I mean, that as an example, one could say, well, gee, you're going to you're going to take your poor tenant that's there, you're going to basically double his rent. Can he afford it? What's going to happen? Well, hate to say it, but vacancy at 0.5 point, if he leaves, not really a big risk in backfilling the space. So that's it. And multifamily is somewhat similar, except in multifamily, we know there's regulations around increases. So it's not exactly, 3 years out, boom, I'm gonna double my income. That's not the way it's gonna be. But we also know there's turnover. We also know with multifamily, the risk level is extremely low because people are, we have housing going up. People are going to be renting. There's no doubt about it. So if I'm looking at that rent roll, I'm going 600, 700, $800. Say it's a 12-plex. I'm looking at these, and I know the market's 1,100, 1,300 for a one bedroom. Then, I may take that risk, and I may do that. That is really all I have. I do have interesting stat that I felt was, and this is, when we talk about investment, certainly on the national front, we do need, you'll see in these slides, you'll see anybody who talks about, they talk about the banking issue in the state. First Republic, JP Morgan, or being the savior of things. But this is what's going to happen this year and over the next few years may be a little worse than what we're seeing. I mean, I don't want to be the doomsayer here. Look at George. Yeah, I know. But the facts are the facts, and it's just interesting stats. So this year alone, within this year, over $167 billion of office mortgages are coming due. So we all know New York City probably has the, in fact they do, they have the lion's share of the office. So if I'm in New York City and I have an office building, my vacancy is up about 12%, so I'm 12% off. My interest rate has doubled, and now I have to remortgage. I'm telling you, the lending institutions are looking at that going, ooh, this is not good. And from a landlord's perspective, he's digging in his pocket for his keys. His mortgages over the next 4 years. That's a big nut. That's a big number. Now, 4 years, let's hope those are the tail end, maybe 3.5 years or something. But, because we're all pretty confident interest rates and things are going to come back around. But anyhow, a little tidbit of information, not trying to be doomsday or anything. And yeah, that's all I got. Thanks.
Easy, but
So certainly we know of one that looks like that. easy as people think. So there's a lot that simply can't be done because it just doesn't work. And yeah, George, I've heard the exact same thing. It's not easy to do. So yes, it can happen, but I think it's, quite frankly, I think it's more the rare occasion than it is the easiness. Any other question? Hey.
Any industrial market actively plans?
I mean, how much, how much more certainly St. Thomas they've done a knockout job, and others in the room may know better than I, but I think they bought 1,800, or they're in the middle of buying 1,800 acres out there, and there's going to be auxiliary, spinoffs. Obviously, no different than Cami when we saw that going. There was spinoff after spinoff after spinoff. So, I mean, industrial's so tight right now, it's hard to fathom. There's got to be a lot of buildings start, whether it be spec or, the design build world, but it's going to make it even tighter. All right.
Thanks, Rick. Well, I know we're all feeling very upbeat after that presentation, as well as all the lease enforcement and other issues this morning. But so that concludes our seminar. Unless there are any, first of all, are there any other questions for any of the panelists before we wrap up? Seeing none. I want to thank everyone for attending today. For those interested, we are able to provide a copy of the recording. There is, I believe, a sign-up sheet, or let one of us know. And otherwise, the speakers will be around for a little while to take any follow-up questions you'd like to ask or to chat. You're also free to connect with any of us on LinkedIn, send us an email or give us a call. On behalf of Lerners, thank you once again, and we hope you enjoy the rest of your day.